My lord will kindly take the PIL, my lord. PIL number 6 of 2021. 6 of 21, my lord.
6.
Yes. Renumbered as PIL 44 of 22. My lord will kindly come to page number 45. This is the amendment which you have challenged. 31st of May 2021. Pursuant to the decision of the Council of Ministers, which was obtained by means of circulation and conveyed by Political and Cabinet Department, white dated 25/5/21, and in the interest of public service, Governor of Mizoram is pleased to make the following rules further to amend the Mizoram selection of candidates for higher technical courses rules 2016 as follows. My lord will kindly come to amendment of Rule 5, with which we are concerned. In Rule 5 of the Mizoram selection of candidate for higher technical courses Rule 2016, Sub-Rule 1 shall be substituted by the following. All applicants shall be classified as follows for the purpose of allotment of seats. A. Open category. B. Children of local permanent scheduled tribe ST Mizoram, residents of the state of Mizoram as category 1. Children of other local permanent scheduled tribe ST non-Mizo resident of the state of Mizoram as category 2. Children of other non-scheduled tribe non-ST permanent resident of the state of Mizoram, and children of parents who are serving under the government of Mizoram, autonomous bodies, etc. as category 3. Children of state and other state government employees not permanently staying in the state of Mizoram as category 4. So these are the 5 categories, my lord, in which, my lord, the students have been categorized. Then my lord will kindly come to the next page. Explanation. For the purpose of this sub-rule, the term open category shall include candidates belonging to any of the scheduled tribes of the Mizoram who have been permanently residing in the state of Mizoram, provided that to be eligible for consideration under open category, the candidates should have passed class 11 and 12 from any of the schools within Mizoram state recognized by the government of Mizoram. That means, my lord, if somebody wants to claim any admission to any educational institution of higher technical courses, my lord, the open category which shall include any of the scheduled tribe, including everybody, my lord. But there is one rider. The rider is the candidates should have passed class 11 and 12 from any of the schools within the Mizoram state as recognized by the government of Mizoram. The term Mizo shall mean those who are geo-ethnic indigenous people of the state of Mizoram and have been residing permanently in this state, and term non-Mizo shall mean non-geo-ethnic scheduled tribe people of the state of Mizoram and have been residing permanently in this state. So, my lord, the Mizo and a distinction is sought to be made within the class of scheduled tribe between Mizo, that is geo-ethnic, and non-Mizos. 2. Sub-rule 2 shall be substituted following, namely, percentage of seat allocation shall be 4% for open category, 93% for category 1, 1% for category 2, 1% for category 3, and 1% for category 4. If 1% is less than 1, then in such case it will be rounded up as 1 seat. Provided that to be eligible for consideration under category 2 and 3, the candidates should have passed 11 and 12 from any of the schools within Mizoram state recognized by the government of Mizoram. Provided further that to be eligible for consideration under category 4, either of the parents, wherever is serving, should have been posted in Mizoram continuously at least for the last 3 years, and the candidates should have passed 11 and 12 from any school within the Mizoram state recognized by the government of Mizoram. My lord, this is the rule which is under challenge. Now, my lord, to put it very simply, first, by this rule, a sub-classification is sought to be made regarding the scheduled tribes of the state of Mizoram. Therefore, the first question which will arise is whether it is permissible or not. The law as it stands today, my lord, it does not permit. For the state of Mizoram, for example, if a lordship will kindly come to, my lord, the scheduled caste list, and just show it, my lord. Yes, page 87. Page 87, my lord. Towards the bottom part, Roman 17, Mizoram. This is the, my lord, 1950 scheduled tribe order under the constitution. Chakma for whom we are representing, my lord. This is the first one. Dimasa, Garo, Hazong, Mar, Khasi Jaintia, any Kuki tribe, including so-and-so, so-and-so, so-and-so. Then my lord will kindly come over to the next page. So many, people are there, my lord. Serial number 10 is any Mizo, Lusai tribe. Serial number 10. So therefore, in terms of Article 342 of the Constitution of India, my lord, the power vests with the president. The power never vests with the state government. It is the prerogative of the union, my lord. Yes. My lord may kindly have a look at Article 342, my lord. The president may, after consulting the governor, specify the tribe or tribes to be ST in relation to the state. Now, my lord, then the second aspect is regarding, my lord, prescription that, my lord, the candidates must study class 11 and 12 in the state of Mizoram. Interestingly, my lord, while prescribing that, it has not been prescribed in respect of Mizo. Kindly see once again, my lord. Please come to 46, my lord. First, my lord, will kindly come to page 45. 45, my lord, rule 5B. Children of local permanent scheduled tribe Mizo residents of the state of Mizoram as category 1. Am I clear, my lord? Then, my lord, others are non-Mizos are category 2. Children of non-STs are 3. Central government and state government employees 4. Now, please come to, my lord, next page, 46. The term open on top, the term open category shall include candidates belonging to any of the scheduled tribe of Mizoram who have been permanently residing in the state of Mizoram, provided that to be eligible for consideration under open category, the candidates should have passed 11 and 12 from any school within the state of Mizoram. So, in respect of open category, it is prescribed. Then, my lord, will kindly come to Rule 2. Rule 2 proviso, which has been now inserted, provided that to be eligible for consideration under category 2 and 3, the candidates should have passed class 11 and 12 from any school within the Mizoram state. Now, in respect of category 1, this prescription is not there. So, that is the discrimination. My lord, in Assam, this particular clause was challenged, but the Honorable Court has upheld because it was uniformly applicable to all. Unlike in the state of Mizoram, where, my lord, requirement of studying in the state of Mizoram in class 11 and 12 has not been prescribed for category 1 candidates. That is the dominant Mizo community. So therefore, my lord, it can't be. Now, my lord, lordship need not take any trouble, my lord. The exact same rule was put to challenge and it has been interfered by this honorable. My lord will kindly come to page 60. The judgment of the division bench starts at page 60. I'll have your lordship's kind attention to page 64. The rule before its amendment, my lord, it stood like this. Please come to page 64, 2016 rule. 5. All applicants shall be classified into 3 categories for the purpose of allotment of seats. Children of permanent resident of the state of Mizoram as category 1. Children of other permanent resident of state of Mizoram, that is category 2. Children of central or state government employees not permanently residing in the state of Mizoram, category 3. Earlier, the rule, the predecessor rule, my lord, was this. Explanation. The term permanent resident means those who are geoethnic people of the state of Mizoram have been residing permanently in the state. The term other permanent resident means those who are children of non-geoethnic people of the state of Mizoram and have been residing permanently in the state. Children of parents who are serving under government of Mizoram, corporation or autonomous bodies under the state. Government who are regular employees of such organization and in whose case it can safely be inferred that they would reside permanently in the Mizoram, including the children of deceased employees of the state government whose families have been residing in the Mizoram. And lordship may kindly skip over to the next page. To be eligible to be considered under category 3, either of the parents of the candidates should have been residing and posted in the Mizoram for the last 3 years. We're not concerned. 2 is important. Percentage of seats for category 1, 2, and 3, 95% of the total seat shall be reserved for category 1, that is, my lord, geoethnic tribe. 4% of the total seats shall be reserved for category 2, and 1% of the total seats shall be reserved for category 3. That means 95% is for people of Mizoram and 5% for others. Now, my lord, this rule was put to challenge. Now, let us see, my lord, how this was dealt with by this honorable court. My lord will kindly come to page 69, para 16. In Millen, that is my lord 2001, 1 SCC page 4. The Honorable Supreme Court had observed that the Parliament alone is competent by law to include in or exclude from the list of the scheduled caste and scheduled tribe specified in the notification issued under clause 1 of the said article. Whether a particular caste or a tribe is a scheduled caste or a tribe, as the case may be, within the meaning of the entries contained in the presidential order issued under clause 1 of article 341 and 342 is to be determined looking to them as they are. In E.V. Chinaya, that is my lord 2005 1 SCC 384, the Honorable Supreme Court held that scheduled caste list prepared by the President under 344(1), in our case it will be 342, forms one class of homogeneous group for the purpose of the Constitution, and therefore subclassification or micro-classification of scheduled caste or scheduled tribe would violate Article 14 of the Constitution of India. So in these two decisions, my lord, Supreme Court has taken this view. The question that has arisen for consideration is whether, for the purpose of allotment of seats, categorization as contemplated in category 1 and 2 could have been legally made. The facts in Chennai were that State of Andhra Pradesh had appointed a commission to identify the groups among scheduled caste found in the list prepared by the President under Article 341 of the Constitution, who had failed to secure the benefit of reservation provided for the scheduled caste in the state in the matter of admission to professional colleges and appointment to the services in the state. Accepting the report of the commission, the state by an ordinance divided 57 castes enumerated in the presidential list into 4 different groups, namely A, B, C, D, based on their inter-se backwardness, and fixed separate quota for reservation for each of these groups. Accordingly, 15% reservation of scheduled caste in the state of Andhra Pradesh for admission to higher education institution and in services of the state under Article 15.4 and 16.4 of Constitution of India was apportioned among the groups, namely A, B, C, and D, by allotting so-and-so person respectively. In the aforesaid factual matrix, the Honorable Supreme Court held that Constitution intended all castes, including subcastes, races, and tribes mentioned in the presidential list to be member of the one group for the purpose of the Constitution, and this group could not be subdivided for any purpose. Argument advanced that to fulfill the constitutional obligation to provide opportunity to weaker castes, it is permissible to make classification within the classes was repelled by the Supreme Court. As a sequitur thereof, it was also held that subclassification or micro-classification of the scheduled caste or scheduled tribes would violate Article 14 of the Constitution. It was also held that if benefit of reservation are not percolating to members of scheduled castes equitably, measures should be taken to see that they are given adequate training so as to enable them to compete with others, but that would not justify to make further classification by a micro-classification. It was further held that a uniform yardstick must be adopted for giving benefit to the members of the scheduled caste for the purpose of the Constitution, and accordingly the impugn legislation was struck down as ultra vires the Constitution. So the Andhra Pradesh government, the ordinance which was issued, my lord, which was struck down by the Supreme Court. The Honorable Supreme Court said, if the benefit of reservation is not percolating to a particular section within that class, impart them adequate training, make them, try to make them at par with the others so that the benefit of reservation as provided under 341 to scheduled caste percolates to even to the weakest among the weaker sections. Now, para 18, my lord. In the instant case, categorization under Rule 5.1 of the 2016 rules professes to be on the basis of permanent residency. But permanent residents have been subdivided into 2 groups, namely permanent residents and other permanent residents. Permanent resident means only those who are geoethnic people of the state of Mizoram, or in other words, people belonging to Mizo tribe. The other permanent residents mean those who are non-geoethnic people. Categorization outwardly does not reflect that any attempt is made to make classification within the listed scheduled tribes mentioned in the principal SIP. However, there is no gainsaying the fact that Mizos and Chakmas are scheduled tribe under the Constitution Scheduled Tribe Order 1950. The objective of classification under Rule 5 is stated to be to reserve percentage of seats for the purpose of admission in higher education institution. If that be the objective, the scheduled tribes who figure in the Constitution Scheduled Tribe Order and who are permanent residents of the state of Mizoram could not have been placed in two different categories of permanent residents. Any attempt to differentiate the members of the scheduled tribe who figure in the presidential list under the Constitution Scheduled Tribe Order 1950 by any parameter such as permanent residency, etc., would amount to fiddling and tinkering with the presidential list, which is not permissible in law. Benefit of reservation has to be uniformly applied to all scheduled tribes listed under the Constitution Scheduled Tribe Order 1950. And it cannot be countenanced that one tribe would get higher percent of the reservation and another lower. In that backdrop, the basis of categorization, whether it was on the basis of performance in the STEE for the last 5 years or on the basis of appearance of students in STE in the last 5 years, carries no significance. Moreover, under Rule 5.1 of the 2016 rules, Chakmas and others are non-geo-ethnic children are made to compete with children of regular employees of the government who may belong to general category. That itself cuts at the root of the professed stand of the government that geo-ethnic people were placed in category 2, non-geo-ethnic people are placed in category 2 in order to subserve their interests. One swallow does not make the summer. The case of Niba Chakma has to be seen in that light. If non-geo-ethnic permanent residents are suffering from greater disability, opportunities should be created for their upliftment and development. The very idea that non-geo-ethnic permanent residents would vie only for 4% of the seats along with the regular employees of the government, while more advanced geo-ethnic community will have the benefit of 95% seat, is a step backward and which will over a period of time further widen the gulf between these two groups and push down the non-geo-ethnic people in the social ladder. It's a very scathing remarks, my lord. In view of the above, we are of the opinion that the impugn rule placing non-geo-ethnic people of the state of Mizoram in category 2 cannot be sustained. It is further observed that they have to be placed along with geo people of the state of Mizoram. Correspondingly, liberty is granted to the state of Mizoram to refix the percentage of seats to be reserved for the categories of the candidates as mentioned in Rule 5. Having regard to the fact that more than 2 years had elapsed, we do not consider it appropriate to interfere with the admission taken under the impugn rule. Now, in spite of this judgment, my lord, now the new rule has been brought into force, which I have already read. They retain the same thing. My lord, first come first, it is the prerogative of the central government to the President of India to declare who is a scheduled tribe. State has no power, my lord. At least under the constitutional scheme, state has no power. Now, before I make my other submission, the other day, my friend Mr. Das, appearing for the state of Mizoram, made a submission. Where is the judgment? Made a submission, my lord, that this two judgment which was relied upon by the learned division bench of this honorable court in a Punjab matter has been referred to a larger bench. Therefore, indirectly what my learned friend was trying to submit is, we should await what the Supreme Court decides. But that is not the correct legal position. Honorable Supreme Court has said, if there is a reference, then the law which is holding the fill on the day, that will be applicable. On that, I'll just rely on one small judgment, my lord. 2012, 11 SCC 321. 2012, 11 SCC 321. My lord will kindly come to para 23. Para 23. Similar argument as has been made by my learned friend was advanced. Para 23, my lord, at page number 327. 2012, 11 SCC 321.
Ashok.
Yes, Ashok Sadarangai. Yes. Paragraph 23, my lord.
How does it start?
The learned additional solicitor general content that.
Para 16.
এখন কি দিছে আপনি? SCC নাকি?
This is legal.
Oh, maybe some other. Well, it happens, my lord. Different journals, I do not know how different paragraphs. Well, my lord may kindly have that paragraph. Learned Additional Solicitor General contended that having regard to the divergent views expressed by different benches of this court, when the same issue surfaced in Gyan Singh, wherein the decisions in B.H. Joshi, Nikhil Merchant, Manoj Sharma came to be considered, the bench comprised of 2 judges was of the view that the said decision required reconsideration and directed that the matter be placed before a larger bench to consider the correctness of the said free decision. Mr. Jain urged that as the same issue which was involved in the present case was also subject matter of reference to a larger bench, this court should abstain from pronouncing judgment on the issue, which was the subject matter in the said reference. So that is the argument here also, my lord. Now, my lord will kindly come to paragraph 29. The sentence starting with, as indicated in Harbhajan Singh's case. As was indicated in Harbhajan Singh case, the pendency of a reference to a larger bench does not mean that all other proceedings involving the same issue would remain stayed till a decision was rendered in the reference. The reference made in Gyan Singh's case need not therefore detain us till such time the decisions cited at the bar are not modified or altered in any way. They continue to hold the field. Therefore, my lord, a reference made in a particular bench is of no avail. So the Honorable Supreme Court says the law which is holding the field today, notwithstanding the fact that it may be a subject matter of reference, will continue to govern the rights and obligations of the party. Therefore, my lord, my short submission in this case is this writ petition, this PIL has been filed by Mizoram Chakma Students Union. It was filed in the year 2021 because, my lord, we were sought to be denied admission into medical courses based on this particular rule. Though there was an interim order of this honorable court, my lord, we are never admitted. This contempt proceeding is also there. So 21 gone. Even in this season, my lord, only the other day, because of several interventions by this honorable court, one girl, Chakma girl, has been admitted. So that is that. Now, my lord, not only in medical, there's so many other courses, technical courses are there, where all applications, where admissions will be governed by these particular rules. Therefore, my submission is, my lord, prima facie, not prima facie, my lord, out and out, this rule is discriminatory. The same rule has been held to be discriminatory by this honorable court. Now, in spite of the pronouncement of the judgment, again, my lord, the rule has been amended, incorporating ad verbatim the same provision. So therefore, in my humble submission, my lord, this rule should be struck down and they should be directed, my lord, to forthwith, my lord, come up with a rule which is consistent with Article 14. Otherwise, my lord, it doesn't behove well on the part of a government, my lord. When a constitutional court has declared a particular rule to be bad in law, and to reiterate that, I can appreciate, my lord, if a validating legislation is brought in, where, my lord, the basis of the judgment is taken away, and a new rule is, my lord, incorporated, taking note of the basis judgment, then that is called validating legislation. That is not the case here. It's, my lord, trying to overreach the judicial authority of this honorable court. But this obstinacy is not good, my lord. End of the day, rule of law has to prevail. Otherwise, my lord, there will be chaos in the society. Kindly see, my lord, where do we go other than to coming to the constitutional courts? So here is a case, my lord. First, they cannot make further classification. Whole of the scheduled tribe for the state of Mizoram, they have equal right. Now, what they have done, my lord, they have given 94% to the, my lord, Mizos, and to non-Mizos, they have given only 1%. 1%. So this is not done. And I think I don't think had it been a case where in the earlier round of litigation, this judgment would not have been there. I may have to, took your lordship's more time to convince our viewpoint. Now it is already settled. What do I argue, my lord? I have just to point out the facts. Therefore, my humble submission is, my lord, I reserve my right of reply, subject to what my learned friend on the other side says. It's an open and shut case, my lord. Lordship will interfere with the impugned rules and direct them to do the admissions of the all technical courses by following a norm, because they'll have to frame a rule afresh. Some rational norms, so that, my lord, everybody get a fair chance. I can appreciate, my lord, you can have some, for example, my lord, in medical admission, Supreme Court has recognized some percentage for the state quota seat. 15% for all India quota seat. Something like that. Because, my lord, now the only problem which will come in the way of the state of Mizoram is, first, we all know the concept of protective discrimination as a proposition which was, my lord, propounded by Honorable Justice, my lord Krishna Iyer in that medical admission case. Now, these are why it is called protective discrimination, because, my lord, when there is an ex facie deviation from the equality rule, then, my lord, it is called protective discrimination. Why it is called? The idea is to uplift somebody to a particular level so that one can compete. Now, in the medical admission cases, what was done, my lord? For example, in the Assam rule also, 85% is for the state of Assam, as in all over country. This legislation is permissible based on empirical data. Now, if in the state of Mizoram, we take the empirical data, Mizoram is one of the states in the country where the literacy is the highest in the country. So there will be a problem. They can't say Mizo people are backward. Today, if you look at the All India services, my lord, many Mizoram people are doing their services. In fact, they are very well off. On the contrary, look at this plight of the Chakmas, where they are, my lord. On the contrary, my lord, there is a requirement on the part of the Mizoram state to come up with something for the Chakmas and other tribes who are, at the lowest state, not the vice versa. Vice versa is not permissible because you are already developed. So you can't make any protective discrimination based on empirical data. If you take note of data, it will be otherwise. That's why it is said, my lord, when state makes a protective discrimination, then the burden is upon the state to prove why it has done. It is not on the citizen. So therefore, my lord, having regard to all these aspects, since the division bench judgment has already dealt with the issue, pronounced the judgment, and which has been Supreme Court. My lord, against the division bench judgment, the matter went to Supreme Court also, my lord. Oh, I'm sorry, my lord, I must have. Please come to page number 73, my lord. Page number 73. State of Mizoram, in fact, my lord, preferred an SLP. Special leave petition is dismissed as a sequel to the above. Pending interlocutory applications, if any, stand disposed of. Then, my lord, a review application was filed by the state in this Honorable Supreme Court at page 74. That was also dismissed. So, my lord, the order of the division bench of this Honorable Court has attained finally. So, there is no gainsaying now, my lord, on the part of the state that the reference is pending. Therefore, my lord, we should have it. That plea also is not available now, in view of the clear position, made clear by the Supreme Court of India. So in that view of the matter, my lord, Lordship will allow this writ petition, strike down the rule, and in the interregnum, my lord, my humble submission is all these admissions should be done in a very transparent and rational manner, my lord, taking some yardstick which is non-discriminatory. That's my humble submission. Otherwise, my lord, I'll be repeating the same thing. I need not take your lordship's valuable time, my lord.
What about the other writ petitions?
My lord, oh yes, my lord, in fact, 285 is by a particular candidate. 285 is by a particular candidate. Same issue, my lord. I adopt the same argument as I have done in PI 44 of 20.
So if whatever judgment comes in PI,
that will cover the other cases. And there is one contempt petition, my lord, where, my lord, in the earlier round of litigation, when there was an order for giving admission, which was not given in respect of 2 students. So for that contempt, anyway, my lord, now those have become academic. Of course, my lord, contempt is there, but I'm pressing the contempt, not really. No, we're not pressing the contempt, my lord. Lordship will decide the case on that. Because I cannot get back my admission. Even if they go to jail, I'll not get the admission. But they should not have done that. When there is an order of the court, either they should have tried to vacate the order, or in any case, my lord, they have gone to Supreme Court, they filed review, it was dismissed. So 285, same, my lord. I adopt my argument as in PL 44 of 20. In fact, my lord, this petitioner, Monita Dewan Chakma, she has been admitted this year, my lord. But the other one, there was another candidate, she did not get. She would have got, in fact, but my lord, because the state was delaying, she took admission in some private college, na? Yes, Monita Dewan Chakma, she has been admitted in the current year, my lord. That too, after, my lord, many. Earlier, my lord, when in 2021, she should have got, she was not given, she again appeared in the current examination, she again got, secured more than 300 marks. Then, my lord, she has been given admission. Only girls she has been given. Because the other one, the petitioner number 2 in 285, she could have got it, but my lord, because of the delaying by the state, she had taken admission in some other college. Effectively on merit, my lord, same issues. The validity of the rules. Number one, just to sum up, my lord, whether they could have made further classification, and two, whether they could have fixed the quota as has been done. Because the Honorable Court said that within that tribe, you cannot make further classification, therefore you cannot make the quota also. The division bench operative portion is very clear, my lord. We are praying the same relief. That's my humble submission. As I already submitted, my lord, it's not a question of my lord. End of the day, this procedure of this Honorable Court has to have some sanctity. He cannot, my lord, as a respondent, he cannot seek relief in my petition. That's a fundamental principle of law. So let him make the same argument by filing a writ petition in Aizawl bench. Why my learned friend is traveling to Gauhati? Because this relief can be given to him by the single judge of this Honorable Court. How can I'll definitely object, my lord. We are fighting for the last so many years till that our rights have not been ventilated. On top of that, they are seeking, she wants to become a party in my case as a respondent and seek relief. Which law permits it, my lord? It's a fundamental principle of law. As an OP, he cannot seek relief in somebody else's case. Let my learned friend file a writ petition in the Aizawl bench, and he may be given an appropriate order. He's not even required to make us party there. I think it will be very difficult for our lordships to accept his prayer in the present form. Well, I'll just take 10 minutes time to reply to what my learned friend Mr. Das has argued, my lord. My lord, my learned friend has referred to 342A3.
My lord, I am for the impleaded respondents in the writ petition. In the PIL, I am not a party, my lord. We have been admitted. The writ petition, basically, I am there, my lord. We have been admitted, and as per my instruction, both of the petitioners have been admitted.
My lord, before my learned friend,
The one did not get it.
I think my learned friend did not even submit also, my lord. Now, I don't think his clients will be interfered anyway.
If my clients are not being interfered, my lord, I'll not.
No, for the purpose of what had happened. What had
I'll not
already,
open.
no, my lord. We were 3, out of
No, no, no.
one got admission. The second, my lord, she took admission somewhere else. And third, because of mark, possibly she cannot get. So therefore, at this stage, displacing my learned friend's client may not arise. For at this stage, for the future admissions to take place, that's a different aspect.
My lord, we have been admitted. If my lord observes, makes the records that observation, my lord, I'm closing my arguments. I'm not going any further.
You are admitted by 9-3 or that.
No. We are admitted on merits, my lord.
A stage came in this proceeding where this Honorable Court felt if we are to be accommodated, against which seat we will be accommodated. Naturally, we are 5. So court passed an order, whosoever is,
Five.
down below with 5 lesser marks, those candidates should be put to notice, because in the event writ petition or writ PIL is allowed, then they will be affected. That is how they came into the picture. Now, my lord, while that stage was going on, state made a submission. In spite of giving all these admissions, there are still 3 vacancies. Against that vacancy, one of us got it. So that way, my lord, I don't think any occasion will come to disturb my learned friends.
My lord may only record that.
Yes.
For both the PIL as well as this, my lord, I'll not make any submissions for that.
No. This doesn't, now doesn't arise. Because
No, I'll not make any submission. That's why I say. Why should I, my lord? My client's interest is protected.
Yes,
Why should I?
my lord, let us assume the reference is answered in favor of, as was sought to be, my lord, referred in this Devinder Singh's case. What will happen, my lord? 342A3 will come into play with full force. Now, what is the fulcrum? On what premise, my lord, the state will make the classification? The idea is what? Idea who is amongst the backward class who are more backward. Now, can we say Mizos are more backward than Chakmas? Is this test, my lord? My lord will kindly have Devinder Singh judgment for a moment. I'll just refer to 2-3 paragraphs. Please come to para 43 first. And 49 in your lordship's paper book. Sorry, in the judgment.
Devinder.
Yes. Let us test the case from the perspective that eventually the reference is answered, as has been, my lord, referred by these 5 judgments. Para 49. Providing a percentage of reservation within permissible limit is within the power of the state legislatures. It cannot be deprived of its concomitant power to make reasonable classification within particular class of scheduled castes and scheduled tribes, and socially and economically backward classes without depriving others in the list. To achieve the real purpose of reservation within constitutional dynamics, needy can always be given the benefit. Kindly mark this sentence, my lord. Why this, my lord? Amongst these, the socially backward classes, if there are some classes who are so backward that as far as they are concerned, some special treatment is to be given, then that is permitted. That's why 342A3 has been started with a non-obstante clause, notwithstanding anything contained in clause 1 and 2. The idea is needy can always be given the benefit. Otherwise, it would mean that inequality being perpetuated within the class if preferential classification is not made ensuring benefit to all. Now, my lord, you are providing 90, how much percent? 94% to the geo-ethnic. You are giving only 4% to the others. 1% to the others, my lord. Well, is this the purpose of further classification? End of the day, my lord, every argument has to withstand some reasoning, my lord. It must lead to some logical conclusion. When Constitution recognizes the power of the state by of sub-article 3 of Article 342A, what Constitution meant, in my humble understanding, subject to what your lordship may say, is within that class, if there are people who need more attention, then that should be attended. And that power should be conceded to the state. Is that thought to be done in this case? Or they are to protect the already a group which is dominant, which is otherwise, my lord, from all perspective, they are well off. My lord, that's why I referred to the judgment in, my lord, this Jagadish Sharan's case. Please have the judgment for a moment, my lord. This is 1982 SCC 768.
Copy is yet to come.
Okay. Well, then I'll place the other paragraphs. In the meantime, I'll deal with this, my lord, Devinder Singh. So, my lord, from Devinder Singh, what follows is the power of the state in a given situation to address the needs of more needy amongst that socially backward section. If at all in the state of Mizoram, my lord, between Mizo and Chakma who require special attention, it is definitely Chakma. My lord, classification cannot be based on how many number of applications are filed. My lord, if on the basis of number of applications, a classification is to be made, that means you are giving up this socially backwardness. You are giving giving up the data of who is more educated, who is less educated. The data has to be with regard to, my lord, backwardness, inadequacy of representation. These are the relevant considerations, my lord, in my humble understanding. Then, my lord, will kindly come to paragraph number 51 in your lordship's thing. Schedule caste as per presidential list are not frozen for all the time, and neither they are homogeneous group as evident from the vast anthropological and statistical data collected by various commissions. State law preferential treatment to a limited extent does not amend the list. It adopts the list as it is. State law, kindly see, the state law intends to provide reservation for all scheduled castes in a pragmatic manner based on statistical data. Now, which is that data, my lord? That Geo-ethnic people are more backward, therefore more reservation is necessary. It distributes the benefit of reservation based on the needs of each of the scheduled caste. Then, my lord, will kindly come to para 48. That means 51, 52, 54. Apart from that, the other class out of the scheduled caste, scheduled tribe, socially and educationally backward classes, who is not denied the benefit of reservation, cannot claim that the whole or a part of the percentage of reservation should have been made available to them. State can provide such preference on rational criteria to the class within the list requiring upliftment. There is no vested right to claim that reservation should be at a particular percentage. It has to accord with ground reality, as no one can claim the right to enjoy the whole reservation. Well, it is going against the very argument of the state. It can be proportionate one as per requirement. The state cannot be deprived of measures for upliftment of various classes. At the same time, which is the very purpose of providing such measures, spirit of reservation is upliftment of all classes essential for nation's progress. My lord, idea behind making this reference was this power of the state needs to be recognized. Why? That's the issue, my lord. The issue is this benefit of reservation should percolate to all. On the contrary, my lord, with the help of this law, how can state of Mizoram claim, my lord, that they can make reservation of 94% for the, my lord, geoethnic people and 1% for other group? Does it stand to any logic? Is this the purpose of reservation? So therefore, my lord, when you are talking of, this newly added, my lord, provision in 2021, then you must advert to these aspects of the matter. The idea should be the benefit of reservation within that class should percolate to all. Not, my lord, as has been envisaged in the rule, only 1% for others and the rest are for them. So, my lord, the purpose for which this reference, we do not know what will happen eventually, my lord. Now, of course, since that constitutional amendment has come in recognizing some power, there may be some tinkering with the law. That's why I said, my lord, even if the reference is answered, what difference would it make in this case? Still, the position would be worse. It would be other way around. That's why, my lord, in this judgment, this Jagadish Saran judgment, I think now it has come. If your lordship would kindly come to page 783. Now, this is the first judgment on this point of protective discrimination, my lord. Please come to para 34. Para 34. 1980 2 SCC 768 para 34 at page number 783. Thus, the constitutional principles and limitations are clear and the norms are belighted by the precedents, but their application to the specific situation is an exacting task. The burden when protective discrimination, promotional of equalization is pleaded is on the party who seek to justify explicit deviation from equality. It is the state of Mizoram who will have to satisfy your lordships based on empirical data why they have made more reservation for the geoethnic people and not for the others. The idea of incorporating that list within the meaning of Article 342 is not to help or support a dominant group. Idea is to, my lord, the benefits should go percolate to all. What has the Delhi University stated here? The learned Attorney General frankly admitted that student hesitation without more could not validate reservation and that excessive reservation was an obvious inequality. Nor indeed it is a good plea that illegal reservation is being practiced by other universities and the Delhi University is forced to act illegally in self-defense. Lawlessness under our system is corrected by law and not by counter lawlessness. So it is strange for Delhi University to say our disorderly behavior is orderly because the other universities behave similarly. Once these misguided defenses of direct action by the student or reprisal against such other universities are brushed aside, we come to grip with the real issues. Is there circumstantial justification for constitutionalizing the reservation strategy, especially at 70% plus? So the Supreme Court posed a question. When you are making 70% plus for the Delhi, how are you doing it? Now kindly come to, my lord, paragraph 37. The argument asked in answer is that doors for admission to postgraduate medical courses are almost completely closed for Delhi graduates by all other universities. So protective reservation becomes necessary as the only hope of Delhi student for postgraduate studies. Those real life factors which show that Delhi graduates are denied de facto equality on a nominal scale by exclusionism of other universities and that therefore they deserve sheltered economy, equal opportunity is in actuality by barriers of reservation of a high percentage of seats. Such being the university's defense, kindly mark this sentence, my lord, must be made out, not merely asserted. That means by placing empirical data, this issue has to be not only pleaded, it has to be made out. At the end of the day, these are all matters of statistics. When Mizoram government want to take a stand that they would like to invoke the power under, my lord, 342 capital A sub article 3, then they must come up and place before this honorable court. These are the statistics, data based on which we propose to do this. They can't do because their stand itself is self-defeating. Instead of, my lord, percolating reservation, now they are centralizing the reservation in favor of a dominant group. This can't be permitted. But even, that's why I said, even if Devinder Singh is answered, how does it help the state of Mizoram? Their case is just the opposite. The reason why Devinder Singh was referred, that's not the reason to be traced in the present case. Therefore, my humble submission is, my lord, as of date, the case is covered squarely by the earlier division bench, though an attempt is sought to be made that the issues are different is not correct, my lord. I have already read out from 2016 rules, where earlier it was 3 category, now it is 5 category. The same position obtains. And my lord, there is no manner of doubt that the Chakmas were displaced people from another country, my lord. They're more backward. If at all any reservation is to be made, for Chakma, this would have been separate reservations should have been made instead of the dominant group. So therefore, my lord, the argument of the state and my learned friend Nair, my lord, though he said that I, as an officer of the court, I am saying so, but towards the end he said one thing, that lordship should wait the outcome of the judgment. That was not fair. That submission was a very partisan. That was not as an officer of the court. He should have said, well, law as it stands today, Devinder Singh is yet to be answered. So Devinder Singh's reference will not hold, cannot withhold your lordship's decision. Your lordship is free to take a call depending on whatever outcome or whatever view your lordship takes. Therefore, my humble submission is, my lord, when you plead protective discrimination, then it is your call to establish. It is not petitioner. As a writ petitioner, we need not, because it is a state who seeks to make that claim. Therefore, you must come with empirical data, which you have not. Therefore, in my humble submission, my lord, the plea of the state is perhaps not maintaining. That's my humble submission.
Only a very quick